morning, friends. So welcome on behalf of Global Institute of Biological Society in continuous process of learning medical legal consultancy, friends. Last 2 months, we could not able to get connected to you because of some personal issues in family. But hereafter, we are going to be in continuous touch with you all. And we'll see that we complete the courses as early as possible. Friends, we have already completed IPC, CRPC, and few more topics are left. The most important topic with the Consumer Protection Act and followed by Medical Council and their procedures. We are definitely going to learn about the procedure aspect in court of law. As I repeatedly said, you don't need LLB degree to appear in consumer fora because of the procedure aspect in consumer fora, where as authorized representative also you can get connected, you can appear in court of law, you can argue the matter of a medical negligence, you can practice as a medical legal lawyer. For the purpose of the same, whatever the procedure aspect are required, and we are going to discuss with you all people. So rest assured, in coming days, we are going to be a part and parcel of that. But in all given scenario situation, when I talk about IPC, when I talk about CRPC, when I talk about Consumer Protection Act or Medical Council, the base of every law in relation to medical law is the judgments and laws of country. As we all know, in our country, the constitution runs the country. As per the constitution, the parliament is a superior, MPs are superior, who are the lawmakers. So any law which need to be brought in this country, implemented in this country, if it is a central law, then it must go to parliament. Both the houses of parliament, after the discussion on particular law draft which is put forth, agrees with majority, then it becomes a law. And then once it's signed by the president, it is executed by notification in this country. So every law which is a central law is made by parliament. Very recently, what we have seen under Consumer Protection Act 2019, which got passed in both the houses, president signed on 9th August 2019, but executed by the parliament in cabinet meeting on 20th July 2020. And various other laws. That is the supreme lawmaker. If I talk about the local laws, I'm sorry, state laws, being health sector in concurrent list of constitution, when any topic comes in relation to health, both the people have got authority to make a law. Central and also state. Concurrent list means both the people are allowed to make a law. Only hitch is that center can make a law, but it is on a state to adopt it or not to adopt it. Even they want to adopt, with what modification, what are the changes they need for their state, they are absolutely free to do. Giving example of Clinical Establishment Act 2003, which was enacted, passed by Parliament. But today also, majority or many of the states have not adopted it. Multiple states has adopted, UP has adopted, Punjab, and many of the states have already adopted with some changes or as it is. But Maharashtra, if I talk about Maharashtra state, they have yet not adopted Clinical Establishment Act, even after 17, 18 years of enactment by central government. So 2003 amendment done in 2010, and their further amendment, and that is a law in a country for regulating or regularizing the health sector and clinics and the hospital and other things. Moreover, the good law, but again, being in a concurrently state has got its own power. So for your understanding, like Maharashtra has not yet adopted. Third, state of Maharashtra independently, or any state of country independently, can make a law for purpose of regulating their state. That's the reason in every state you will find, like in Maharashtra, it is Maharashtra Medical Practitioner Act. Same applies to Kerala Medical Practitioner Act. If you go to Karnataka, it is Karnataka Medical Practitioner, KMPA, what we say, Karnataka Medical Practitioner Act. Every state has got their own Medical Practitioner Act enacted by that particular state without any consent or concern with the central government. And that regulates in their state about the health sector. And that is why when we talk about registration part of any of the doctor, it become mandate to have a registration. So I was talking about state laws. When state has made a law of medical practitioner act where they make a mandate for all the pathies, it could be homeopathic, Ayurvedic, allopathic, Unanipathic, Siddha, naturopathy, to register it in their respective state to practice in their respective state. In spite of Section 27 protecting all of the doctor in a central council, I mean talking about MCI, every doctor need to have registration in state if they are practicing state. And there's a lot of conflict and discussion gone in that respect. But being a medical legal lawyer, you should know central law prevails over the state law if it goes in court of law. So you can defend your doctors by central law also in such a conflict where state is going to demand that if at all they want to practice, they need to register with our state. Like Andhra people registered with Andhra Medical Council, automatically got registered under MCI and practicing in Bangalore, Karnataka state, then Karnataka definitely is going to ask a question. Even if you are registered with MCI, why don't you get registered from Andhra to MCI? Same applies to homeopathic council. Multiple cases came to me in respect to homeopathic practice in Maharashtra, where many of the doctors got arrested. I'm using word arrested in spite of having a registration of UP government, in spite of registration in BR government, and registration with CCH. Registration with CCH means Central Council of Homeopathy very clearly says under Section 14 that every practitioner who are registered with Central Council of Homeopathy are eligible to practice homeopathy across the country. They've used across the country. Means the law itself says that people who are registered with CCH, and for registration of CCH, some state registration is required, like UP, BR, and Bangalore, many of the doctors were registered in different states. But I've seen in Maharashtra state, only on the ground of Maharashtra Medical Practitioner Act, where Section 33 very clearly says that all the doctors who are practicing, even homeopathic, Ayurvedic, allopathy, Nanopathy, or whichever pathy, in the country, in the state of Maharashtra, are mandated to register themselves with the state councils. Now, only on this ground, these people were being troubled. There is a big conflict, but unless such a cases goes where you need to be decided that whose laws are going to prevail, this is the conflict which is going to remain. But for your knowledge sake, state government has got own power to regulate health sector so they can make a law. Central government, being in a constitution concurrent list, are already allowed to make a laws in the country so they can make a health law. Now coming down to third part, like in parliament and assembly, the same thing happened. If it all state wanted to make a law, it is passed by all MLAs. They are the lawmaker in both the houses and signed by the governor of that particular state. In center, it is a parliament and signed by the president. Followed by the local authorities. So every local authorities have been empowered to make a rules and regulations or a local act for the purpose of regulating the health sector. Like across the country, we have found multiple Mahanagar Palikas, municipal corporation, who are governing all sort of a cities area, and Gram Panchayat and local authorities or SDM or collector handling that particular local area. For the purpose of local handling, these people are also empowered to make a local rules and regulation, like biomedical waste product disposing of the same in consent with the pollution department under the law of pollution, or various other laws in a local authority, like notifying the disease. It is a local law, a municipal corporation, where if you don't notify this, it become actionable. Various other rules, regulations, and the local laws are made by the smaller body of a government. So these are the hierarchies which we have found that people are following in respect to the law, in respect to the lawmaker. And this is for your knowledge sake. It is most important that you should know how and what way law. But again, let me repeat the same thing for you. The central law prevails over the state law, and state law prevails over the local laws. Second principle of law, let me share with you, very clearly says the principle of law that any rules and regulations which are not incoherent with the act prevailing in this country or act available in this country are not in wavelength with these respective acts prevailing in the country are null and void. Like many of the people write not for medical legal use or repudiated, claim reputation, they will come with some regulation that because of the old disease, because of this disease, XYZ, you are going to be out of the claim. So lots of such a rules you may be finding, and client may be coming to you whose claim has been rejected on frivolous ground. Here again, you can take this principle of law, which very clearly says that any rules regulation made against the act prevailing in the country, because the IRDA Act is different, and this act is going to govern over the local rules and regulations.